Brothers, two Johnson County murder suspects faced a judge. James and Dale Willis are being held on $15 million bond in connection with a homicide outside an Overland Park nightclub. 41 Action News reporter Andres Gutierrez is live outside the courthouse in Olathe. Andres, tell us what the judge said today.
Yeah, Cynthia, this morning the judge combined both Dale and James Willis's cases for the next preliminary hearing that's set for next month. This was a fairly routine hearing that lasted less than 15 minutes. Family members of both the suspects were in the courtroom this morning. The suspects, in fact, nodded at them as they walked into the courtroom, but none of those family members spoke with us after the hearing. Law enforcement sources tell 41 Action News both men are charged for the shooting death of Gerald Carter. Back in September, Carter was shot and killed outside the Roxy nightclub in Overland Park. Police arrested 33-year-old Dale Willis from Kansas City, Missouri back in mid-November. Then on New Year's Eve, police arrested James Willis and charged him also with first-degree murder. Both men are being held on a $15 million bond. Today, Dale Willis's attorney tried to reduce that bond down to $50,000, but the judge denied that request.
That $15 million bond made history in the state of Kansas, even in the nation, with Bernie Madoff with a $10 million bond, followed by Suge Knight with a $25 million bond, making them public enemy number one.
Bird said he need
I came here
100.
to clear my name too.
So they gonna hear it out of their own mouth.
I came here to clear my name too.
Hi, Frankie.
Clear.
Hi, Frankie. Hi, Frankie.
I'm just saying.
Freeman, you want to clear something?
Hey, this is clear my name area.
This is
Clear my name
Let me
area.
make this real
This is clear my name area. We against the brick wall.
real for y'all real quick.
Look, this is clear my name.
Let me check this out. Let me explain to y'all how Bird got subpoenaed into a whole nother situation. You
I'm
feel
trying
me?
to tell you.
My
Bro,
nigga
is this your
understand-
paperwork?
My nigga, understand this. I'm chilling doing my thing. You feel me? I'm in and out of the situation. A nigga try to text a nigga to send a nigga to come and smoke me. I get up out of there. I'm gone. Boom. I know nothing about none of this. Nigga go to jail, police all through the nigga phone, they trying to figure out who Bird is. Nigga, Mac from KC We On, nigga gave the police my motherfucking picture out of this motherfucking camera. Nigga, and nigga, he told them, nigga, this is who the fuck Bird is. So nigga, they came and picked Bird up. And nigga asked me, do I know I was the target of a homicide? But I slid out just in time. I slid out 5 minutes before me getting smoked. I'm like, nah, I don't know nothing. They like, nigga, well, here go the text message that he was sending to this person and this person. You feel me? So this person was sending somebody out here to come and smoke you for $5 grand. I said, damn, for what? He said you had this much amount of money at the bar, so he was sending this niggas out here to come and lay you down. Luckily, I was feeling, I'm a very observant nigga. So I'm watching niggas, but niggas don't know I'm watching them. Nigga, I never get too drunk, you hear me? So I'm watching niggas, I slide out, boom. I slam bro to the car, I send Landmark to the car. While they talking about that, Bird was talking about he had Landmark all the situation, blah, blah, blah. Listen, I send Landmark to the car, boom. Go start the car for me, cuz I'm on the way. I slides out, shoot. I slides out, get in, boom. Once I get in the car, I'm out, boom.
He telling the story like
minutes,
JJ Ice Fish.
Look, 5 minutes later, some dude gets smoked. I don't even know cuz. But just because cuz came up and shook my hand, you know what I'm saying? Like, them niggas felt some type of way about that, so they got some fag shit off of him. Mind you, the detectives asked this nigga, what are you into it with Bird for? I don't like Bird, this and all that. Now I get picked up, now I get subpoenaed, my nigga. In a subpoena, nigga, you have to go to court, nigga, or you gonna have a $100,000 bond, nigga, or sit in jail, nigga, or sit in jail, nigga, until you have to go to court. So every time I was subpoenaed, I got subpoenaed every time I came to court, nigga, and I went to court, nigga. When I went to court, what I say? Yes, I know that, nigga. Do you give a fuck about him? No, I don't give a fuck about him. Nigga, do you recognize him as, yes, I recognize them niggas, we ain't cool. Nigga, no, nothing, nigga, period. Did you see them shoot somebody? No. Was you there when they shot somebody? No. Do you feel that your life is threatened, nigga? No.
Live
I leave.
spicy.
Nigga, I leave. Nigga, you feel, nigga, every time I came, nigga, I said the same motherfucking statement.
In the statement on September 22nd, 2015, Detective Massey and another detective were assigned to interview Tyrone Brown, aka Bird, regarding this investigation. Detectives were able to reach Tyrone by phone and made arrangements for them to meet him at his residence. Detective Massey responded to Tyrone's residence and conducted a voluntary interview with him in Tyrone's living room, which was recorded with a digital recorder and attached to the case file,
I didn't snitch on shit, nigga. You niggas snitched on yourself, nigga.
stated that Papa Willow feels like he's untouchable and always surrounds himself with people he buys off with jewelry and money. Papa Willow is the drug hookup and his money is made from drugs, not his rap music. He also said he heard, based on what he knows about Papa Willow, he told one of his people, meaning artists, to smoke him, which he was talking about Gerald.
So no, nigga, I ain't snitch on no Papa Willow, nigga. Nigga, Papa Willow told on himself, nigga.
In the interview, Tyrone was shown a series of cell phone videos received from Francesca, where he identified Papa Willow in the blue shirt, and in photos, he named numerous other people as well.
You're a damn liar, man. That's not true.
Now the bird is done. Let me clear my name. My name is Francesca Patton. For those of you who don't know, I'm also Frankie Baby. This is my paperwork. I don't ever have to, I don't know if y'all can see it, I don't have to lie to y'all about nothing. I have never, mind y'all, I ain't never heard of this DR niggas before this case or none of that. I was working, I was in the restroom when this incident happened. 50 people was subpoenaed. Even people whose first time being in this building,
Period.
People who had never been there, it's $100,000 fine. None of you motherfuckers is coming to get us out of jail for $100,000. We had no choice but to show it to court. But in my paperwork, where Papa Willow and his brother sat in my face, every time that I went there and sat in there, they heard everything I said. They seen everything I said. I will never, mind y'all, YTB Gasson, Young Twine is my man. He was a part of the DR. Had I been a snitch and this nigga been having my paperwork all this motherfucking time, he wouldn't be with me today. Exactly. Had I been a motherfucking snitch.
In her paperwork, it says she had 3 cell phone videos of Papa Willow that she wanted to show detectives to help them along with their case. She also signed a consent to search form allowing the police department to extract whatever information was pertinent to the investigation from her cell phone. Ms. Patton's cell phone was identified as a Samsung Galaxy Grand Prime. She also made 3 different statements to detectives. In a grainy video surveillance footage, you can see Gerald Carter get punched and falls to the ground. He gets up and jumps in his car and backs up. Prior to that, he had pulled into the space and bumped Papa Willow with his car, where they exchanged words. Then he got up off the ground and said, "I have something for you," which could be heard by other eyewitnesses outside the club. So he backs up and proceeds to leave. Papa Willow and his brother walk alongside the car. Then 11 shots rang out. It's hard to make out anybody in the grainy video surveillance footage. The car backs up and comes to a sudden stop. Witnesses can be seen ducking and hiding for cover, and a lot of witnesses also flee the scene. Gerald received multiple gunshots to the chest. Shortly after that, police arrive on the scene.
I hear you. Okay, all right. Come on, go get him, man. Hey, who was it? Who was it? We need medic. All right. Hey, who was it? Nobody knows who was it. You're trying to help me, please, officer, please. I got you. Hold on. Hey. Just to the west of the door. This block the road there between the bank and the rocks. That's a lot of north and south. The unit covers south parking lot. To the rock. Hold on, come on, Charles. Come on, Charles. Take it back. Come on, he's taking. Come on, Charles. He just took it, man. Keep breathing, my name. Keep breathing, my name. Come on, cuz. Yeah, step back a second, okay? Step back a little bit. All right, let him do his job. Let him do his job. Come on, Charles. Come on. Watch out for the ambulance coming in. Come on, bro. Take another breath for me, cuz. Everybody see it? Come on, cuz. I see it. Breathe, man. Everybody see it. Keep breathing, man. Keep breathing. Breathe, bro. Keep breathing. Relax, man. Breathe. Come on, guys. Breathe, man. Breathe. You got anything to learn, man. Breathe. Come on. Come on, Drew. Breathe, man. Come on, man. Come on, man. Come on. Get back up a little bit. Let that coming. Let him do his job. All right. Pull that open. He take another breath. Take a step back. Take a step back, all right? They're coming in right now. Come on, man. Come on, you right? Come on. Hey, stay with us, man. They're coming right now.
It was about 1:19 a.m. on September 16th of 2015 when Gerald Carter was shot 6 times. 5 additional bullets were fired at him and missed. Those 11 shots were fired by James Willis. Those shots were fired from a Glock 45 caliber handgun that James Willis brought to the Roxy Club that night. And it was all because Gerald and Dale Willis had gotten into a heated argument. They had gotten into an argument that turned physical over a photographer taking photographs that night. It turned physical when Dale punched Gerald with so much force that Gerald fell to the ground. And the evidence will show you that Gerald disrespecting Dale Willis in the manner that he did was enough to get him murdered that night.
But this is that 40-second span when the state claims that James Willis has joined the defendant. That's the brother they claim has the gun. We don't represent James. But in that 40 seconds, what we do know is said is, I'm going to slum y'all, I'll be right back. And people in the crowd say, he's got a gun. Carter's got a gun. And Antonio Frazier, the security guard, will tell you he saw something on Carter's hip, and he said had he had his own gun, he probably would have shot him at that point.
And then the plot thickens. Prosecutors bring out 2 secret witnesses. One was Terry Stewart, a childhood friend of Dale Willis. He placed both brothers at the scene of the crime, and he took the stand, helping prosecutors close the case with them. Stewart had caught a charge, and he wanted to reduce his time, so he cooperated with the police. The second witness was Damon Robbins, James and Dale Willis's cousin. He got caught up in an FBI drug sting, so he testified against the brothers, saying that they were riding around in his car that was seen at the scene of the crime. So he took the stand and tried to reduce his time as well, but ended up getting federal jail time.
Count 1. We, the jury, find the defendant guilty of murder in the first degree. Count 2. We, the jury, find the defendant guilty of battery.
Both brothers were sentenced to 50 years. With an ongoing federal investigation, surveillance cameras have been set outside DOR studios and also outside of Dale Willis' house. After Nut Nut and T9, an artist on DR Records, were both murdered. Co-defendant Constance Anderson, 35, was the victim of a home invasion robbery by 2 armed men, according to federal documents. This style of robbery is common in the Kansas City metropolitan area. and it is usually tied to narcotics trafficking, an ATF agent wrote in a court affidavit. Those robbers left without finding money according to the documents, but in December, investigators searching a safe deposit box belonging to Anderson found $142,000. The search came as part of an investigation into the financial dealings of Anderson and Robbins. Among the purchases documented was a red Ford pickup truck bought by Anderson last summer and driven by Robbins. The truck matches the description in a murder-homicide in Olathe, Kansas. During surveillance, prosecutors said Robbins distributed more than 6 kilograms of cocaine. He was sentenced to 12 years in federal prison without parole. On March 20, 2017, Robbins pleaded guilty to participating in a conspiracy to distribute cocaine from May 22 to December 14, 2015, participating in a money laundering conspiracy from December 13, 2013 to December 16, 2015. Robbins admitted that he provided cocaine to co-defendant Escobar, 26, a citizen of Mexico residing in Kansas City, Missouri, who distributed the drugs to customers and delivered the drug money back to Robbins. During the course of this conspiracy, Escobar and Robbins distributed approximately 1.9 kilograms of cocaine to a law enforcement confidential informant. Escobar has pleaded guilty and is scheduled to be sentenced. Robbins needed someone to hold the proceeds of his drug sales and help legitimize the illegal proceeds during the time period. Robbins did not have a job or otherwise any other legitimate source of income. Robbins' girlfriend, Constance Anderson, 36, of Kansas City, assisted Robbins in laundering his illicit drug money. They had no idea they were being watched the whole time by federal prosecutors. Cameras were hidden on poles. The courthouse was heavily guarded with snipers on top of rooftops during the trial. Defense attorneys argued that the Willis Brothers did not have a fair trial and were sentenced on the wrong guidelines.
It is undisputed that Dale Willis did not shoot and kill Jarrell Carter outside a busy bar in Overland Park. But 3 months after Mr. Carter's death, the state charged Dale with first-degree premeditated murder under the theory that Dale communicated in some way to his brother, James Willis, to shoot and kill Mr. Carter. In pursuing its aiding and abetting theory, the state called 36 witnesses. Not a single one heard a verbal directive from Dale to James to shoot Mr. Carter. Dale's defenses were that he did not direct James to shoot Mr. Carter, but if the jury found that a communication did occur, then it was in self-defense carried out by James. The jury convicted Dale as charged. Dale asked the court to sentence him to the hard 25, which the court denied after making comments about aggravating circumstances and a not required by the law mitigating circumstance. Dale will be 83 years old before he is parole eligible. In our brief, we raised 9 issues, which is an overwhelming sounding number, so I sort of grouped them together. And basically this court, the reasons this court has to reverse these convictions basically fall into 2 categories. 1, the information that was incomplete or incorrect provided to the jury, i.e. the law that they were supposed to use to consider Dale's fate. And secondly, errors made regarding the admission of certain evidence. It is also our contention that overall, when the court considers these errors together, if you do not independently find them to be warranting reversal, that all taken together, that in fact it does warrant reversal. So I guess I would start with the instructional issues that we raise. The more I think about this, the more concerned I get. And that is all of the things that the jury was not informed about the law. For example, with regard to, obviously the entire case was about aiding and abetting, yet the jury was not told, wasn't given sufficient information about what that entails. The jury was not told that the mental culpability required refers back to the elements of intentionally killed and premeditation. Even more troubling is that the jury wasn't told in plain terms that Dale and James both have to be acting with the same intentions. They have to share the same intents. It's not enough if one of them thought that they were acting in self-defense and one of them thought that they were acting with an intent to kill. It's not enough if at any rate, they were not told that in any shape or form.
What's our standard of review on? Well, let me back up. Are you objecting to, on appeal, to any of the instructions that were given? Or are you just making an argument that the jury should have received additional instructions?
Our issue is that the instructions as given, that the aiding and abetting instruction and then the self-defense instructions, that they did not completely state the law that the jury needed to have.
And that leads to my follow-up, which is just what's our standard of review and why isn't this invited error? Because as I understand it, these instructions as given were exactly what the defendant requested.
First of all, it's our contention that we don't even think it's a clear error standard. We actually think that this court should be considering this under the constitutional harmless error standard.
Well, let me just ask a factual question. Is what I recited just a minute ago accurate, that the instructions as given were the instructions that were requested?
I take issue with the word requested. Here's what happened, which is basically what happens all the time in trial courts in the state. The judge tells attorneys to submit jury instructions and gives them a deadline. Sometimes you, even at your pretrial conference, we'd have to fill out these forms saying whether or not we were going to be requesting certain instructions. This is something that's required of defense attorneys, even though they haven't revealed their defense, started their trial, heard what any of the state's evidence is going to be. So basically what happens is, to comply with the court's order, you submit a list of pick numbers, maybe sometimes the language, and maybe sometimes people do ask for specific language in advance. And that's what happened here. The judge ordered the attorneys to file jury instructions, and in fact, at one point the state asked the court to remind them to do that because they hadn't done it yet.
So,
and the court referred to those as proposed instructions.
It sounds like the answer to my question is yes, these were the instructions that the defense requested, but you're objecting to the process.
No, I still take issue with the word requested. Those are the instructions that they submitted. That's not the only instruction I'm talking about. First of all, I do think that there is something. I'm also talking about the aiding and abetting instruction, which was the entire theory of the state, which is the only way that the state could charge Mr. Willis. And there are multiple problems, as we've set out in our brief, with what that instruction didn't say. And that comes down to the very heart of what the jury was to decide, i.e., was Mr. Willis guilty of premeditated murder? And if they were not given all of the law that is a part of that decision that resulted in Dale having a hard 50, then that is definitely harmless. If they are not given all of the law that they are required to find. So we may have a little bit more room to argue about the self-defense ones, but I just think that it is, it's just clear that the jury, in deciding whether he was guilty of murder, was not informed about all of the law, and that is not harmless.
And which specific portion of the aiding and abetting law are you hanging your hat on?
There's at least three different ones. The fact that that when the aiding and abetting instruction talks about mental culpability, that's not defined anywhere. And so jurors don't know that refers back to the intentionally killed and the with premeditation in the elements instruction. The second thing is that they are not told in plain words that Dale and James have to be acting with the same intents. And third, they were not told that Dale has to knowingly associate with the unlawful venture and participate in a way to facilitate that, i.e., the meticulous, extensively planned killing, to borrow some words from the last argument. The juror was not told any of those things. And as this court often says, jurors don't become imbued with this information when they are sworn in as jurors. They have to be informed of it from the trial court, and that did not happen here. And this, as far as reversibility and why this isn't harmless, this is not, despite what the state argues in its brief, this is not a case with overwhelming evidence. Dale was not the shooter. He didn't give James a gun. There's no evidence he disposed of a gun. He didn't give James a ride to the Roxy. He didn't ask him to come to the Roxy to help him with Mr. Carter. And there's no evidence that Dale gave James anything except for maybe a ride away. Well, we know he gave him a ride away from the Roxy.
The group as opposed to those particular individuals. I mean, I understand revenge. You know, I understand those kind of motivations. Right. It seems like to say street law, it's got to be applicable to a certain, at least sociological group. You see what I'm getting, where I'm getting at? And
I do see where you're getting at. There was testimony here that the various rivalries here concerned other individuals to the extent that those rivalries could trigger violence between the parties, and that those parties often resolve those disputes among themselves, oftentimes resorting to violence or carrying firearms, carrying guns. There was testimony about that. There was testimony about Brown himself testifying about potential violence. The defendant himself talked about this imminent threat that was posed, he argued, by Gerald Carter. And so to the extent that the state talked about that, that was a reasonable inference from the testimony of Tyrone Brown when he talked about the culture that existed between the brothers, Dale and James Willis, and their recording label and other players within the rap community that were present at the club that night. Disrespect occurred between the parties regarding a photographer that was on the sidewalk. That's when the punch was thrown, and so on. So to the extent that that one-off line of the prosecutor in closing referring to street justice, it was referring to resolution of issues between these parties when they take actions into their own hands and resolve it with the use of firearms and threats and intimidation and so on.
Is it more accurate to say it's the code of the street and the street law?
That would be a fair characterization, absolutely. That was the code between these different individuals, these different groups, and how they resolve disputes among each other.
In response to the state's argument and also a couple of questions, try and hit on a number of points. First of all, the state, just to kind of correct or clarify some things the state said about the facts, you probably already know this, but the bevy of communication that occurred between James and Dale and other people and the rush to get to the club, none of that had anything to do with Mr. Carter. That had to do with somebody else, and all of those sorts of things occurred before Dale even got into it with Mr. Carter. So it's not that that Dale procured James to come to the club to kill Mr. Carter. That is not supported by the evidence.
I think, as I understand, one of your arguments is there wasn't, the evidence was not overwhelming, to say the least, that Dale had premeditated this killing. And then you connect the dots by saying because the jury wasn't told that that was an element it had to find, this is reversible error. Is that a good summary of your position?
Yes. Okay. Yes.
Can you respond to the other evidence that the state recited that would have supported its theory that Dale met the premeditation element? The things on the video and so on.
The thing I would say about that is that those things were disputed as well. So the state said that it was the hoods were disputed. That's true. They were disputed. But another thing that was also disputed is whether or not Mr. Carter was trying to get away. And so if he's not trying to get away, but rather trying to make good on something that multiple witnesses heard him say, or the way he was acting, or I guess the street law, if the state's going to argue that this is about a culture or a street law or disrespect between the parties, well, that doesn't apply just to Dale and James. It also applies to
You're saying
Mr.
a reasonable
Carter.
juror could look at all this evidence and there's two possible explanations for it, basically.
At least.
And how do we know which one the jury picked if the instructions were wrong?
Exactly.
What about
a point raised by opposing counsel. I'm assuming it's in the record that your client pointed out the victim just before his brother shot him 11 or 12 times.
That was disputed somewhat as well. That had conflicting evidence as well. So, like, for example, the lead detective said, oh yeah, he pointed at him twice. But then she admitted that, okay, well, maybe one of those was like trying to break people apart. I mean, we're talking about a black and white grainy video. Then there was, and then there would be people that would testify about not pointing. So that was even disputed or had multiple viewpoints, if you will. Another point I wanted to make was about Justice Biles. No, I'm sorry. It was both of you, Justice Beyer and Justice Biles, about the comment that, we wouldn't be lawyers if we didn't complicate things. That's no joke. That's not levity. That is not just unfortunate. That is straight up. The state had just agreed that those instructions were appropriate, and yet then wanted to go in there and belittle them. That is not a joke. It's not levity. And as for the 9-day trial, and it's just one phrase in 9 days, you know what? It doesn't matter if it was 9 days or 3 weeks, whatever the case may be. If the wheels fall off at the end, whether that be through prosecutorial misconduct or the way the jury is instructed or not instructed, or cumulatively all the above, it does not matter if at the moment that Dale is supposed to realize these constitutional rights, if that is hindered or obstructed, whatever, by these errors, by prosecutorial error or the court's instructions, it doesn't matter. It doesn't matter. The wheels fell off. That's what happened in this case.
Counsel, you're well out of time.
Okay.
What are you asking us to do?
Well, first and foremost, we're asking you to reverse Dale's conviction and order a new trial. And as part of that, we would ask this court to reconsider its holdings that say that the self-defense instructions and the aiding and abetting instructions give the jurors all the information that they need. And alternatively, Mr. Willis asked this court to vacate his life sentence and remand his case for resentencing, because even in light of Powell, the court erred and also considered information that we believe implicates Dale's Fifth Amendment rights. Thank you.
Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.
Before the unfortunate events, Papa Willow was doing pretty good as a concert promoter. He brought in such acts as Sibo, Mozzie, Joe Blow, and various other artists. Stay tuned for part 2 as we go further into detail about the music and how they tried to use the music against him in court.